Hi everyone, my name is Dylan Grant and welcome to part 11 of my presentation on Ontario Superior Court of Justice Motion Record and Order. I tried to not to make the presentation too long, that's why it's in parts, and as I said, you're already familiar with some of the information that I would provide. It's just that I'm speaking to the tabs, okay? But I will go through quickly. If you want to review, please feel free to pause and read, okay? Thank you. So now we are at tab N, as you can see, tab N, and it should be for this combined statement of combined court order here, but I just believe that the Ontario Superior Court of Justice was also playing along with the lawyers, okay? It says N says email correspondence dated December 18, 2020. Email correspondence dated December 18, 2020. I decided that I would no longer communicate with Neymark Law. I became very uncomfortable after reviewing the affidavit in December 2020. Also, the conversation during the meeting confirmed that this lawyer was deceptive, who did not know anything about my cases, which they had made their own. So December 18, 2020 at 10:38 a.m., Courtney Madison emailed me again, and she said, I spoke with Ryan yesterday. If you are refusing to go to mediation, we need to cancel it today by 3 p.m. to avoid a cancellation fee. And she said we got the January 2021 date last week by a cancellation date. Otherwise, the mediators' next availability is in January 2022. Good for them. Okay, I had to respond. Okay, so at 2:34 p.m., I sent this email to Denise, Courtney, Ryan, Sanjay, Samantha, Bray, and I said, please proceed to cancel the mediation scheduled for January 2021. Okay? And then Courtney is going to say, hi, Delane, December 18, 2020 at 2:43 p.m. She said, per your request, we will request cancellation of the mediation currently scheduled for January 21st, 2021, though it is against our recommendation to do so. Can you let me know why you don't want to go to the mediation? Can you answer that question for her, please? This is the best option for the mediation of your long-term disability and wrongful dismissal claims. The wrongful dismissal claims that she said she did not get anything as yet, eh? But anyway, would you have gone to the mediation? Okay. Please feel free to review. Thank you. So this was what was in the motion, retrieved from motion, December 18 from Denise Coy. All right. When I guess they're giving them the news, right? It says, good afternoon, ladies. I've reviewed instructions to have the above mediation scheduled for January 21st, 2021 cancelled. Okay. That was from Neymark Law, Denise Coy. Please review details on the deception of Neymark Law, December 2020. Now we're at tab O. We're getting there. 2 more to go. Tab O. After this one, 2 more. Email correspondence dated March 24th, 2021. Okay. O. Email correspondence dated March 24th, 2021. I don't think I had that one. No, I did not. P. Order of the Honorable Justice Mandate dated April 23rd, 2021. You see, they wouldn't have anything on me, because since 2020, December 2020, I'm not responding. Right? So whatever is what they want to do. And again, I wouldn't care less if I'm not showing it here, because guess what happened? This whole thing is not mine. It was the lawyers. They put me through the motion. I'm sharing with you, okay? Order of the Honorable Justice Mandane, dated April 23rd, 2021. Okay, tab P. Order of the Honorable Justice Mandane, dated April 23rd, 2021. Okay. The order. Okay, this one's so interesting now. I thought the lawyers were confused when they created a combined statement of claim, but was falsely created to further confuse my cases. This was one of the reasons used to cancel the examination for discovery dated September 29, 2020. Okay. One, the defense lawyer do not wish to have them combined. We already went through this. I'm not going to go through this again. All right. We know about this combined thing. But look at this now. It says here, the combined. This is what I'm explaining up here. We dealt with it already, right? They said they don't want it combined, yet it's combined here. And an order on this false thing that was created by the lawyers combined. This is supposed to be null and void, thrown out. Okay, here. Okay, I'm gonna enlarge it. Okay, as you can see, Bearability Inc. is included. Please feel free to read here if you wish for understanding, but it should not have been a combined order. This does not exist. I'll tell you, this does not exist. What does it contains? Okay, this was falsely created by Nicklini Law to confuse my case. So how come the court is approving this and then giving me order? Okay, it says this motion brought by the lawyers of the plaintiff for an order removing Ryan Neymark Professional Corporation. You know, when you can recall that letter from Ryan Neymark. The letter from Ryan Neymark had two sections there. It says manufacturers life insurance and alliance insurance and financial services, and the next one was Mobility Inc. Right? Two separate, because he said one, the manufacturers life insurance company, industrial alliance insurance and financial services, it says long-term disability. Then it says B, Mobility Inc., and it says wrongful dismissal. Please feel free to go back on that letter when it says that is not, all my four cases were not gonna be there. This law firm Neymark Law said that they're no longer gonna represent me, right? So how come everything here is combined? Okay, please feel free to review. However, the court is saying there's no cost for this motion, eh? Could not be. Please feel free to review. Thank you. Here it only says Grant versus Money Life Insurance. How confusing are they? Now we are on Q. Letter dated July 14, 2021. Tab Q. Letter dated July 14, 2021. End of index. That's it. Okay. Motions, confirmation, and notice from the Ontario Supreme Court of Justice. Intent of Nick X. Morley Law and Nicklini Law, Neymark Law Firm. Okay, 2021. If I were involved in the creation of the claims, I kept saying that, okay, I would have created 3 separate cases to claim damages. I would have created Bell Mobility Inc., wrongful dismissal and damages, right? May 24, 2018. I would have created a statement of claim for Money Life Insurance Company, short-term disability, April 2nd, 2018 to May 1st, 2018, and damages. I would have created a statement of claim for Industrial Alliance Insurance and Financial Services for long-term disability, May 2nd, 2018 to present, and damages. That's how it should be, but no. The lawyers made sure it wasn't so. Okay, please feel free to review. Thank you. Okay, I would have created Bell Mobility Inc. since Neymark Law obtained the statement of claim, wrongful dismissal, and statement of defense, wrongful dismissal from Sanford to Marken Law. They placed it aside and did nothing. 2 years later, the court of law dismissed the claim. As you can see, this was correct. This one was correct. Okay, for the most part, that is. Motion vulnerability, wrongful dismissal. Neymark's law request to be removed from my case. A case Neymark law sided with Nicolini law and Ixmorley law to ensure that I lose in the court of law. A case that was already prepared by Sanford Markin law and not Neymark law. A case Neymark law recognized a year and 2 months later that I did not work for Bell Canada but Bell Mobility. A case Neymark law stated on September 29, 2020 that they were not prepared for the examination for discovery, wrongful dismissal. A letter dated September 26, 2019, received in October 2019, stated I had to wait 10 months, July 26, 2019 to May 15, 2020, for the examination for discovery, wrongful dismissal. The examination for discovery, wrongful dismissal was postponed for another 4 months, May 15, 2020 to September 29, 2020, to be told they were not prepared, therefore required more time after 1 year and 2 months. Then to be told by Neymark law over a year later that the examination for discovery should have been for long-term disability and not for wrongful dismissal. Neymark law cancelled the examination for discovery without my consent in September 29, 2020. Okay. Below was the order for May 12, 2021, Bell Mobility Inc. Got an order, eh? Court file number, as I said, 2022. Okay. Neymark law took my wrongful dismissal case, Bell Mobility, and deliberately did nothing for my case because they sided with Nicolini law and Ixmorley law defense to have my case thrown out. Mobility was guilty at all levels since they had provided proof. Since I had provided proof. 2 years delay, my case was denied and closed. Please feel free to review. And as you can see, Dealing Grant and Mobility Inc. And it says order, and it says this motion brought by the lawyers of the plaintiff for order removing Ryan Neymark Professional Corporation OA Neymark law. Okay, so Master Weeb is providing, is giving this order, okay? And it says here again, this court further orders that there will be no cost of this motion. No cost. Why? Because Neymark law did nothing. All right, please feel free to pause and read. Okay, went through this already in my presentation on Neymark law. The manufacturer's life insurance company, Money Life Insurance Company, or should it be manufacturer's life insurance company, Industrial Alliance and Financial Services Inc. and Mobility Inc. Which is it? Okay. Here, combine here. It says combine here. Throughout my short-term disability, I was in communication with Money Life Insurance Montreal's office. So again, they have Toronto's office. See, statement of claim was false. I will not waste my time to go through this rebuttal from Money Life. Okay, affidavit from Manon Lacroix. Okay, remember this. Please feel free to review. Thank you. Please feel free to read if you wish, because it's nonsense. This has nothing to do with me, but the lawyers, okay? September 15, 2021. Okay, it says motion confirmation notice, Dealing Grant versus Manufacturers Life Insurance Company. Okay, and it says here, please find attached our motion confirmation notice for court file. This is for Money Life and Industrial Alliance, Dealing Grant versus Manufacturers Life Insurance Company. Where is Industrial Alliance? Okay, this is not the combine, eh? You notice the combine there at the front page, eh? Okay, And it says here, Delane versus Manulife, Manufacturers Life Insurance Company. Where did that come from? There's no statement of claim with just Manulife. You see? You see what happened here? Wow. Anyway, it's supposed to be combined. Which is it? So you see they keep interchanging, all right? You see the confusion. Okay? Instead of a combined thing, now Manulife is on its own. Please feel free to review. Thank you. Okay, it says Grant versus Manufacturer's Life. The Manufacturer's Life they're dealing with here. And it says Barbara Zaplote, I think that is. Okay, to Joanna Manulife and Morley Law and myself on September 21st, 2021. That is, right? She said here, please see the attached endorsement of Justin Dennison, dated September 21, 2021. Grant versus Manulife Insurance. Okay, please feel free to review. Thank you. The manufacturer's insurance, I see now, they're including Industrial Alliance Insurance and Bell Mobility Inc. So you see they're using things interchangeably. So supplementary motion record, Morley Law, date September 9, 2021. And my. I was in compliance, eh? They say I was not in compliance. This is a motion by the defendants, Industrial Alliance Insurance and Financial Services Inc. and Mobility Inc. pursuant to rule whatever. I was in compliance and they just did not give me any time to take part in my cases. Lawyers were deceptive. Please feel free to read. False pretense. Nope, I was just going through making my little doodles here. But all lies, okay? Feel free to review. Thank you. All lies. So again, if you can read, the court of law is no different from the lawyers. The evidence is brought to the court was clear to confirm that the lawyers misrepresent, because they can't be coming with combined statement of claim and then you see just Manulife, then you see just Industrial Alliance, then you see Bell Mobility separate. They are so confused, right? Please feel free to pause and read. I won't really go through this because, as I said, with a motion like this, it cannot be about me. It cannot be about my claims because my claim has not yet started. It has not yet started. Only claim actually was started. That had started was Bell Mobility with Sanford Road to Marking Law, wrongful dismissal, right? I was yet to meet with Benjamin Law for him to correct that statement of claim. All right, the meeting was planned, but because of Naymark Law, we didn't get to Benjamin Law and I didn't get to meet. Okay, but I would have rectified that part of it for long-term disability because it was incorrect what Adrian Nicolini did. Okay. More information here. Please feel free to read. Okay. Because Morley Law is saying here that she changed her counsel 3 times. Dates have been set for examination for discovery. Some stuff here as if I was doing a lot of things that were illegal. If you can read here, the defendants, Industrial Alliance Insurance and Financial Services Inc. and Mobility Inc. see costs. They see costs, on they see costs on a partial indemnity basis in the amount of $2,000 for the motion and $15,000 for trial preparation. Okay. The lawyers did all that, and I must pay for their deception. Can you imagine? They're slick, I tell you. I was never involved. Why now? Did not attend. Did not want another murder attempt because it mentioned that I did not attempt. Can you please review? Thanks as you go along. Okay. Please feel free to read. All right, if you can. I as I said, this was not really about me. This is what the lawyers did, okay? So that the cases would be thrown out. They succeeded. This is part 8 of the motion. All right. As I indicated here, confused motion. I will enlarge this for you. Okay. You see on page 5, if you read it, right? As I said, I didn't want to go through all that. It's not about me. It's not about me. I was going through, just scanning through and making my little notes here and there, but it's not about me. Okay. On page 5, item number 25, stated costs, right? The defendant's Industrial Alliance Insurance and Financial Services Inc. and Mobility Inc. seek costs on a partial indemnity basis in the amount of $2,000 for the motion and $15,000 for trial preparation. That's what it was outlined. That's what was outlined on page 5, right? The defendants submit that they prepared affidavits of documents in this matter and yet never received affidavit of documents from the plaintiff. That's what they said, eh? They never received. Well, the lawyers didn't do that, right? And they didn't know anything. So they deliberately, see what happened here? It says, I read it again. The defendants submit that they prepared affidavits of documents in this matter and yet never received affidavit of documents from the plaintiff. I didn't know anything about it. That's why I didn't get anything. So you see how the lawyer was setting me up to fail. So imagine if I attended that mediation. Wow. Item number 26 also stated counsel for the defendant Manufacturers Life Insurance Company seeks cost in the amount of $500 for today's motion. So payment, from what I gathered from page 5, payment should be $2,000 plus $15,000 plus $500, which would be $17,500, right? However, this is page 8, number 33 and 34. Okay, it says on page 8, item number 33 stated, ultimately, I am satisfied that it is fair and reasonable that the plaintiff pay costs to Industrial Alliance Insurance and Financial Services Inc. and Mobility Inc. in the total amount of $15,000. Okay? $15,000. $2,000 for the cost of the motion and $13,000 for the costs expended preparing for trial. Okay, you notice here it says 15,000, but here it says 13,000, giving a total 13 plus 2,000, 15,000. Okay. Item number 34 also stated, I am also satisfied that it is appropriate for the plaintiff to pay costs to Manufacturers Life Insurance Company in the amount of $500 for work on this motion and attendance in court today. Payment as per the motion, it says payment right here, 33 and 34, 15,000 plus 500 equal to 15,500. And I got 15,000. It was said here 13,000 plus 2,000. So at least they didn't get the 17,500, but that was stated there. I guess they didn't realize that. I forgot the name of the person who put forward this motion. I guess he didn't realize that he made a mistake. All right, mistake is good, but again, as I said, I shouldn't have to pay this because it had nothing to do with me. I was actually given 2 different amounts for payment within the motion. Okay. Anyway, please feel free to pause and read. Thank you. Lawyers created false statements of claims without my knowledge or involvement. The lawyers had never met with me once to discuss my cases, wrongful dismissal and long-term disability. They made my cases their own by omitting the negligences of the other entities. 3 years later, I was informed that I should attend the mediation for settlement. I declined since I was unaware of my cases, which were misconstrued. Also, that I had lost trust in the medical system. Yeah. Yeah. I did not attend any of the motions filed against me by Neymark Law or Morley Law, so as to avoid another attempt on my life. I decided not to disclose in private the evidences I had against them. That's why I'm doing it public. Yeah. And the Superior Court of Law, right? Yeah. What the evidences I have. These lawyers found time during the pandemic to quickly resolve their matter against me, but used the pandemic to delay my cases. I decided to go public. Should there be another attempt on my life, I hold all entities involved in my cases responsible, mainly the mobility, my life insurance, Morley Law, Nicolini Law, Neymark Law, the medical system, and all other entities, systemic racism. Okay?